like to welcome you all to this, our second annual Moot competition. After a hugely successful Moot last year and great interest in participating, we opened the Moot to all practice areas. And I'm pleased that we have lawyers from competition, tax, corporate, litigation, and employment participating this year. We have dedicated the Moot in honor of one of our great litigators, Evans Monari, and I hand over to Agnes to share a tribute to him.
Thank you, Bianca. Very good morning to everyone, and warm greetings to our Mooters of the day. We are approaching about a year since Evans physically left us. Numerous tributes were posted online, from the highest office of the land to the ordinary man. His network was that wide because he treated everyone with respect and dignity as he captivated the legal profession. In his legal career, Evans has done it all, from state counsel to practicing in almost all the top firms in the country, and finally senior partner at Bowmans at the time of his passing. He took on the legal field with a career defined by humility, grace, elegance, and a tireless work ethic, defying all odds to achieve a successful career. To those who worked with him, Evans was more than a boss. He was a mentor and a father figure. Despite exemplary academic prowess, as well as representing the high and mighty, Evans was very humble. He generously gave wise counsel. Evans was overly proud to see people succeed, and he took an interest in the growth of each member of his team. Evans truly served as a beacon of hope and stability for his team. He was fun-loving, full of insight, and pleasant to work with. When you worked under Evans, you meant a great deal to him. He would welcome you with open arms and extraordinary generosity. Time and again, his team was struck by his humility, the way he put people at ease, and how he brought his considerable humor and charm to moments of great difficulty. Evans keenly followed the last Moot competition and even shared his thoughts. He was very proud of everyone who participated and the submissions that were brought forth. As we start the Moot competition today, may the participants be inspired by Evans' legacy. All the very best to each and every participant, and I wish the judges fruitful deliberations. Thank you.
Thank you so much for those moving words, Agnes. Right, we're going to move across to the formal proceedings now. Presiding over the proceedings this morning is our distinguished panel, consisting of Mr. Tim Gordon-Grant, Senior Litigation Partner in our Sandton office, Cecil Kuyo, Partner in our Nairobi office, and Kabuela Chisaka, also a partner in our Sandton office. This is an application for the annulment of the Tribunal's award in the matter between Commerce Group Corp and San Sebastian Goldmine Inc. versus the Republic of El Salvador, ICSID case number ARB/09/17.
Thank you. I hope I can be heard by everyone. My panel members have been introduced. Good morning to the participants and the people attending. To the litigants, we've read the papers. We've obviously read your memorials, or what are often called heads of argument. This is very much a type of appeal panel, that it is annulment proceedings, and the purpose of the bringing of these proceedings is to annul the decision of the Arbitration Tribunal. The arbitration is being conducted under the rules provided for by CAFTA, which is the Central American Dominican Republic Free Trade Agreement. As a matter of housekeeping then, each party is permitted 30 minutes to present. And the way it'll work is as follows. The claimants will present, the respondents will have an opportunity to answer, and the claimants will have an opportunity for rebuttal. The 30 minutes, the claimants will have to use their skills to determine how they use their 30 minutes, because it's a maximum of 30 minutes, which includes both their argument and their rebuttal. And the rebuttal may not exceed 7 minutes. So we will watch the time and we will give you due warning as to how that is going. Just before we begin, one more thing. The arguments, or the people arguing, have 3 minutes of what is called protected time. So the first 3 minutes of the claimant's argument and the first 3 minutes of the respondent's argument, we as the panel will not interject. It's only after the first 3 minutes that we can participate freely with you. So please use that time well. To me, this is very much a question of jurisdiction and whether the tribunal had jurisdiction to entertain the claims of the claimant. The tribunal ruled against the claimant and found that it did not have such jurisdiction. And very much of this jurisdictional requirement comes down to the meaning of waiver. And very briefly, that is dealt with, and it's in the heads of argument, by Article 10.18.2 of the CAFTA articles, which requires that no claim may be submitted to arbitration, and I paraphrase, unless it is accompanied, the notice of arbitration is accompanied by the claimant's written waiver. So we're dealing very much with what the meaning of the waiver means. And the article goes on to say it's a written waiver of any right to continue or initiate before other bodies similar proceedings. And I'm paraphrasing because the issue here is, what does the waiver mean? It either means, and this is the central issue, it either means that all the claimant needs to do is deliver a written waiver when submitting the proceedings, we hereby waive, and whatever it is, or it means more than that. They must deliver that waiver, and it must be accompanied by conduct which is consistent with the waiver, which would include withdrawing any other proceedings or not initiating any other proceedings. So it's either just a simple I hereby waive, or it's more. Having said that, then I think we will begin. And it is obviously the claimant who will commence. And I shall start a timer. And whoever is presenting on behalf of the claimant, please introduce yourself and then commence. But please, I reiterate, we have read your arguments, so we would appreciate it if you don't just read them to us. So I call on the claimants.
Thank you very much. I will act on behalf of the claimants. At first, I hope you can hear me. My name is Alexander Niebler. I have worked for the competition department team in the Cape Town office of Bowmans under the supervision of Tamara Dini. And it is my pleasure, dear honorable members of the panel, to act on behalf of the claimants, which are the Commerce Group Corporation and their Salvadoran subsidy, San Sebastian and Goldmines. So ultimately, the claimants are an American company. That we, our team A, have the pleasure of addressing the tribunal team today in the matter of the claimants against the Republic of El Salvador. And before I start with the arguments, I would like to give a very brief summary, brief outline of the facts, that we all know what we're discussing about. And afterwards, the structure of our arguments, and that is also important in regard to protected time, will be as following. I will start, we have 6 arguments in total. I will start with the first 2. After me is going to present Sami Nazarali from our team, and Richard Odongo will take on the last 2 arguments. And the 4th member of our team, Moshka, she will do the rebuttal. So just for your information, how we will structure our presentation. Thank you very much for for having been able to say that. I'm going on with the presentation of a brief outline of the facts. Claimants have been active in the exploration of gold and silver in El Salvador for about 40 years. They have been granted exploration and licenses and environmental permits until the year 2034. And in 2006, the government, the El Salvadorian government, single-handedly decided to revoke the claimants' permits for mining, processing, and exploration, which is their sovereign and autonomous right to do so. However, they have to respect applicable foreign investment law and, most importantly, the CAFTA regulation. And that is the reason, because the claimant, disagrees with the fact that they have not been offered compensation based on numerous articles of the CAFTA, that they first initiated and instituted proceedings in domestic courts in El Salvador, and afterwards, then on 17th of March 2009, they served El Salvador a written notice of intent to submit the claim to arbitration, pursuant to the ICSID Convention and pursuant to CAFTA. So that is more or less the brief outline of the facts, because then what happened after that is the members of the panel, as has been already described for, the tribunal issued an award which more or less said that they will not take jurisdiction based on the fact that it's not within the jurisdiction of the arbitrational tribunal to discuss the matter of debate. Our approach is now to file for an annulment of said award, based on the fact that we say that with that award, the tribunal manifestly has exceeded its powers, which is pursuant to Article 52, number 1b of the ICSID Convention, and that the award in that regard must be annulled. And if I may repeat, we say that not only the tribunal has exceeded its powers, but it did so manifestly. Now, why did it do it? I'll start with my first argument very briefly, because we won't have much time. We are not disputing the fact that there might be a material and a formal element in regard to the obligation to discontinue. The question is more or less, and there's no debate about the fact that we have issued, which can be seen in Exhibits A and B, a written waiver in regard to, or compliant with Article 10.18.2 of the Convention. But we did not act on behalf of that. More or less, we did not undertake positive steps in regard to discontinue local proceedings in domestic El Salvadorian courts. And the question is whether or not that should have been necessary. If it would have been necessary, then the award in that sense is correct, or if it not have been necessary, then it isn't. The first argument which we present to you is based on the very simple approach that when we as the claimants would have actually been required to discontinue local proceedings before the award, before the arbitrational tribunals in the first instance actually decided on whether or not to take jurisdiction, there might have been a situation which would leave the claimants with no possibility, to be heard. Because if we would have had to discontinue local proceedings in that regard, and in the same time, for one reason or another, the arbitrational tribunal would have not taken jurisdictions, then we would have been left with nothing at all. And that is simply against the fundamental right to be heard. And that is also, and that is the core element of our first argument, not the sense of Article 10.18.2. This argument can be supported by the fact that the arbitrational tribunal itself has asked the respondents two preliminary questions in regard to the legal effects of the tribunal not accepting jurisdiction. So they saw that problem. And although the respondents in that case answered on them, it is very clear that there might be different outcomes in regard to the possibility of reinstatement in the different national civil proceeding laws of the member states of CAFTA. And that therefore it's not in the sense of Article 10.18.2 to more or less say, yes, you have to end domestic proceedings and hope for the arbitrational tribunal actually to take jurisdiction. That is the first argument. I will now go on to the second argument, which is going to be...
Excuse me, Mr. Niebler. Just
Yes.
a question. So what you're saying is you want to have your cake and you want to eat it, in the sense that even if you're required to waive your rights, you want to keep them alive, so that if you don't do well in the arbitration or fail in the arbitration, you can still go back and continue your local proceeding. Is that what you're telling me?
No, that's not at all what I'm saying. What I'm saying is that the claimants must be left with a possible, if the arbitrational tribunal, and it's just based on the question of jurisdiction or not, if the arbitrational tribunal does not take jurisdiction, then the claimants, which have already filed their intent to discontinue proceedings, must have the possibility to continue, because otherwise they would be left with no forum at all.
So are you saying that the claimant must stay the proceedings, so to speak, the local proceedings, put them in abeyance?
Just until the moment when the arbitrational tribunal takes jurisdiction. In that moment, there is no debate about whether or not the claimants have to discontinue proceedings. Of course, they have to do that, because we then have a forum, which is the arbitrational tribunal. But until then, it is unsure from the claimant's perspective. There's a high risk of the arbitrational tribunal not taking jurisdiction, and it would contradict the sense of the article then to impose on us unilaterally the obligation to discontinue and believe in the mere fact, in the mere possibility that the arbitrational tribunal takes on jurisdiction.
And do you accept that if we find against you on that and find that you were obliged to withdraw and effectively end the local proceedings, then you must fail in this hearing?
That is one of the core arguments of ours. Yes, no, it's not the only. We have 6 arguments in total, but it's well, the argument which I just presented. Yes. So if you're not agreeing with me, then yes.
And I'm hearing you. Thank you.
All right.
Counsel, one additional question from me, just a follow-up from the president. What is your understanding of the intention of the waiver provision?
Our intention is more or less that the intention marks the intention to, as soon as the arbitrational tribunal accepting jurisdiction, just discuss the proceeding in the arbitrational procedure and not in a different form or a different venue anymore. And that is what an intent also means. An intent is not a clear statement. That's also the terminology of it.
So that, I mean, if you say that the intent is not to have parallel proceedings, then the intention would be that the waiver should be effective. So you remove the domestic court proceedings and proceed only before one forum, before the tribunal. Would that be
absolutely? And we're not disputing that, but only after the tribunal actually took on jurisdiction. Only after that period.
Just to tell you, you have 20 minutes left.
Yes. Okay, so I will very briefly do that so that we have the time to also talk about the other things. We in our second argument, we say that by adding not only 2 elements, 2 requirements, like the formal to actually send the intention of discontinuing proceedings with this written waiver, but also to add a material element, and also mark a very specific time period, which is in the case of the award, that we have to discontinue proceedings before the tribunal has decided on whether or not to take on jurisdiction. They have violated and they have departed from the plain language provided for in the CAFTA without legal basis. And the case law cited by the respondents in the first case does not deal with that. That is our second argument. And now I'll hand over to my colleague, Sami. Thank you very much.
Thank you.
May it please this tribunal. Sorry, I can't see myself. Okay. May it please this am I audible, sir? Hello, am I audible?
Yes, I
Okay.
can hear you. Yes.
Okay. So may it please this tribunal, I will be submitting on points C and D referred to in the claimant's memorial, namely that the burden to discontinue judicial proceedings in local courts lies on the respondent, and D, the claimants had claims based on El Salvador's revocation of the claimant's exploration license, which are not in litigation before the domestic court. I will submit on them separately, starting with C firstly. Primarily the plain, as submitted by my colleague Alex, the plain wording of Article 10.8.2 does not mention anything concerning the responsibility to discontinue local proceedings, if at all, in the case law cited by the claimant in Waste Management 2, the tribunal held there was a duty of the respondent to plead the waiver before the local courts. In the present situation, however, the respondent has only pleaded the waiver in pre-arbitration proceedings and not during the has not pleaded them in local proceedings. The rule created by the tribunal in the award is not consistent with the plain language of the waiver provision, nor with the logic of 10.8.2. There's nothing in the waiver provision that the claimant must take affirmative steps to discontinue domestic proceedings, let alone when the claimant is not even requested to do so by the respondent. In the case of Vanessa Ventures, there were two legal proceedings, there were two legal rationale that were held. Number one being the delivery of the signed waiver committed the claimants to irrevocable consequence with respect to the domestic proceedings. And number two, it also held it for the court or the tribunal in the domestic proceedings to address the effect of the waiver. So if at all case law supports our interpretation, it is not for us to plead the waiver in local proceedings in the local forum. Moving on to the second point.
Mr. Nasralli, just before you move on, with your understanding of 10.18.2 that it operates as a defense to the respondent in domestic proceedings, or that it is a condition to be satisfied before the tribunal accepts that it has jurisdiction to hear the matter in the arbitral forum.
Yeah. Sorry, could you please repeat your question?
Sure. Is your understanding of 10.18.2 that it operates as a defense to the respondent in domestic proceedings in the way that you've described, that it must be raised by the respondent in domestic proceedings? Or is it a precondition to be met in order for the arbitral tribunal to find that it has jurisdiction to hear the matter in the arbitral forum?
Could we address the response to that towards the ending, if possible?
Perhaps I could just come in there. I had a similar question. I think what you're saying then, Mr. Nasralli, is it is sufficient, as one often sees in commercial agreements, that the claimant should say, I hereby waive, and whatever it is, I hereby waive a particular right. And in doing so, then it has complied with the CAFTA article, and the defendant can then use that waiver in whatever way it wishes. For example, it can use that waiver to negate the domestic proceedings or as a defense to the domestic proceedings, and therefore the waiver is good. Is that what you're telling us?
Yes.
Thank you.
Yes. And that is the interpretation that the previous tribunals have held in the cases cited in the memorial. Moving on to the next point, that is the claimants had claims based on El Salvador's revocation of the claimant's exploration licenses, which are not in litigation for the domestic court. The gist of the matter is that the proceedings before the local court in El Salvador were concerning a review, seeking a review of the Ministry of Environment's decision to revoke the environmental permits issued for the mine and processing plant. While the present arbitration did include those claims, it also included further claims concerning El Salvador's refusal to renew the exploration permits. So there were additional causes of action in the current arbitration proceedings. So as a result, the tribunal should have been more prudent in proceeding to separate the causes of action if it found that the claims concerning the revocation of the environmental permits were overlapping. It should have dismissed the claims to be overlapping to be within the jurisdiction of the National Court and proceeded to determine the revocation of the exploration permits. However, at present, it blanketly dismissed the entire claim without considering the separation. The claimant cannot waive rights that are not in dispute in the first place for the local court. What was in dispute for the local court was revocation of the environmental permit. So that was waived. However, we cannot waive anything that's not in dispute. What I'm referring to is the fact that the exploration permits were never in dispute in the first place. So the claimant cannot waive rights that are not in dispute. Even if the tribunal finds that the burden to discontinue local proceedings lied on the claimant, the tribunal proceeded to dismiss claims that are not in dispute in the first place before the local court. That alone is sufficient in annulling the award since the tribunal exceeded its jurisdiction. The decision to separate the claims has been decided in previous case law, as cited in the memorial in the case of Railway Development Corporation. That is the end of my submission. Are there any further questions?
Mr. Nazarali, just one question from me.
Yeah.
Just to take you back, you cited the case of waste management.
Yeah.
It seems to advance, or it seems to suggest to me that in addition to the waiver, it must be shown that there is a genuine waiver. Maybe educate me for me to understand, how would a tribunal go about establishing a genuine waiver? Can you hear me?
Yeah, I can. Could I please take that question at the end of the submissions, just so that I can respond to it appropriately?
That's okay. Thank you so much.
Yeah. Are there any further questions?
Just one. Insofar as, and this is generally for the claimants, insofar as there is reliance upon authorities here,
yeah,
and particularly arbitration decisions, I take it the claimant is familiar with Article 26, 10.26, sub-article 4, which says an award made by a tribunal shall have no binding force, except between the parties themselves in respect of that particular case. My question then is, to the extent that you rely on arbitration authorities, I take it you do so because you believe that persuasive.
Yes, just so that the tribunal is guided by previous decisions for the sake of consistency.
Thank you.
Yeah. Yeah, is there any further questions?
Just to tell you how you're doing on time, the claimants, you have about 10 minutes left.
Okay, I'd like to pass on the floor to Mr. Richard.
Thank you.
Yeah.
Thank you, Zamin. Good morning, honorable members of the tribunal.
Morning.
It's our pleasure to meet our case and arguments to you. In the interest of time, I'll quickly tackle last two limbs of our argument, namely whether El Salvador's ban on mining constitutes a measure under CAFTA, capable of arbitral proceedings. I'll also tackle the argument whether the dismissal of the tribunal, the claimant's claims, based on the respondent's violation on foreign law would be valid. So on our first argument, we wish to submit that actually El Salvador, as my co-counsel Alex Nabler mentioned, is a sovereign state with jurisdiction and power to actually cancel mining licenses and exploration licenses. However, this should be done in accordance with the principle of foreign law and the investment treaty entered into by El Salvador as well. We submit that it would be a very high administrative oversight, for the government to issue statements later after revocation of licenses, acting retrospectively in that regard. And we also submit that this would be in violation of foreign law, specifically Articles 5, 6, and 8, on non-discrimination of investors, and also the proper compensation to be done, especially where investors have already invested into the country, setting up mining operations, and actually employing the locals, etc. Not to mention also incorporation of a local company. We also submit that this would be a violation of the ICSID Convention, specifically to allow investors to seek refuge or to seek recourse to arbitration proceedings where local courts or local law has no remedy or measures available to parties. On the question of waivers as well, waivers are specific and intentional in the sense that a party can waive its rights, but also with regard to this specific legal question raised by the respondents, whether it should be an affirmative action on the respondents' end or the claimants' end. I wish to agree with my colleague Samin and actually, submit that the affirmative action would be by parties, however, would be by the claimant. However, the tribunal should also note that local proceedings cannot be stopped immediately in that regard. I wish to move on to my the second argument on whether the dismissal would be basically in violation of foreign law. It's a claimant's argument as raised in our memorial that actually it is a violation of foreign law, especially to do with the revocation of the licenses, number one, but also number two, just the statements issued by the minister, the local El Salvador minister. I wish to reiterate my argument and state that, again, Article 5, especially on equal treatment of all investors, should be upheld by, first of all, states, and secondly, by state corporations. On the principle of compensation, we also submit on behalf of the claimants that indeed, if any permits were to be revoked, there should be due compensation for any costs up to the stage at which the licenses were revoked. We do submit also and refer to the award, especially at paragraph 127, that we actually made substantial arguments in this regard through our references to Article 25 of the ICSID Convention, as well as Articles 5, 6, 8 of the Investment Foreign Law of El Salvador. I wish to also, state that I'm open to taking any questions from the tribunal.
Thank you. Might I just say that our interjections, to be fair, I believe we should give you an extra 4 minutes, claimant. So your total time left now is 10 minutes. But remember, you also are needing to do rebuttal. 10 minutes left. Thank you.
Thank you. I think at this stage, then.
Just one question from me, Counsel. This your understanding of the Convention, Article 52(1)(b) of manifestly exceeding, the tribunal's power. My understanding is that it should be clear and obvious. Is that your understanding too?
Yes, it is.
So that it means that the tribunal should not be unduly burdened in perusing and finding out the reason. It should jump out, it should be obvious, should be clear. Isn't that so?
Yes, it is.
Okay.
However, I think on that ground, what we do is to submit is, given the context under which the revocation was made, having taken active steps, I think we should submit that, taking all facts into consideration, especially to do with the waiver, it then makes it a very convoluted issue, in that would then need to actually rely on provisions of both local law and foreign law. And so in that regard, it wouldn't be manifestly apparent to the tribunal at first instance. Hence your adverse finding on that ground specifically.
Okay.
Also, dear members of the tribunal, just to come back to the question in regard to the genuine waiver very briefly, so that is also in line with our arguments. We are not disputing that the genuine waiver complies the material and the formal element. What is important is the time period of when to discontinue local proceedings. And that is also why it is an intention and not a statement or a proof that we discontinued local proceedings already. The intention is the formal element, and discontinuing only after the award has accepted, only after the tribunal has accepted jurisdiction is the material element. And those are the two elements which together form a genuine element. And now I think it's fair for us to use the rest of the time for rebuttal. Thank you very much.
Sorry, Tim, you're on mute.
Apologies, thank you. That means you will have 7 minutes for rebuttal. Thank you to the claimants. I call upon the respondents. Thank you. Who's up for the respondents? Yeah, thanks.
Thank you, Mr. President, and members of the committee, members of the claimants, and members of my team, the respondent. I greet you. The claimants are citizens of the United States, which is a party to the CAFTA. The waiver requirements in Article 10.18.2b of the CAFTA track really closely to the corresponding text of the NAFTA, to which the United States is also party to. Now, committee, this submission will become pertinent later on as I proceed with the respondent's position. However, before setting out the respondent's argument, the respondent submits that on the close reading of the claimant's papers, these annulment proceedings become a re-litigation of what the claimants think should have happened during the tribunal.
I'm so sorry to interrupt, Mr. President. Unfortunately, I can't see counsel. I don't know if you can see her on your end.
Yes, I cannot either.
Nor can I.
Oh, I don't know. Let me restart and see if.
Not that we are insistent, but
no,
in case you want to be seen, we can't see you.
Yeah.
Am I visible now?
No.
No, just your name.
Oh my goodness.
We can get on. I mean, if there's a problem with the we can get on.
All right. We don't
Yes,
wish
Mr.
to distract you, but you're just not on, but we can hear you very clearly.
Awesome. Mr. President, I think we will have sight of my face later on, and what's important right now is the voice. I have no idea what is going on with this. I had tested the video. I apologize for that.
Good.
Oh, I am getting guidance from IT. Let's see. My apologies. Okay.
While you're looking at your notes.
No, not even.
Well, while you're considering while you're considering that, just a thought that has occurred to me before we go on, or before you go on, and not that it's necessarily pertinent here, but a waiver I think in most jurisdictions, is a contract, in a sense that the waiver needs to be communicated to the other party. But I don't think that's an issue here, since that communication is a given, because it formed part of the submission. Thank you. Ms. Magongwane, would you continue?
Thank you, Mr. President. I have been in liaison with the IT, and they said I can just proceed also. We will investigate at a later stage what seems to be the problem. Without any further ado, Mr. President, I take this opportunity to deal with the respondent's case in the manner that we will present it. In the first instance, now that the claimant has made certain concessions, I will just briefly reiterate the respondent's case on the first and the second ground. My colleague, Mr. Mazibu, will deal with the claimant's second, third, and fourth ground of annulment. And my colleague, Ms. Nyoma, will address the committee on the fifth and the sixth ground of annulment brought by the claimant. Mr. President and the committee at large, in their submissions, the claimants relied on the Malaysian Historical Salvos case and the Vivendi Universal cases. And I understand at this point that the committee is not bound by any previous decision, but just to highlight the mistaken understanding of the claimants that there is indeed access power that is manifest. The reliance on those two decisions is misplaced in that the Malaysian Historical Salvos case, the ad hoc committee in that matter found that the tribunal had exceeded its powers in disregarding the applicable law, and it had nothing to do with declining jurisdiction. And in Vivendi, the matter confirmed that the powers of annulment as set out in Article 52 of the ICSID Convention were limited only to those grounds, and in particular, that annulment proceedings were not appeal mechanisms. And in this instance, committee, I would like to refer also to Article 53 of the ICSID Convention, which seeks to preserve the principle of finality and the binding nature of arbitral awards. And now, without belaboring the point, in relation to that waste management decision in which I earlier indicated that the United States to which the claimants are citizens is bound by the NAFTA, and that the wording of the NAFTA and the CAFTA are closely related. In Waste Management 1, the tribunal considered that the waiver provision implies that there's formal and material act on the part of the claimant. And this was dealt in length by the tribunal in paragraphs 79 to 87 of the tribunal award. Further, the tribunal considered the submissions made by the Republic of Costa Rica and the Republic of Nicaragua, who are member states to the CAFTA. Mr. President and the committee at large, now also tying in with the second ground of annulment that is brought by the claimants, the respondent submits that after having considered and accepted the submissions of Costa Rica and Nicaragua, the tribunal also looked at the language, the purpose of the article, of the waiver provisions, and accepted the interpretation that the claimants were required to formally and materially withdraw or waive their claims. Now, there's a decision that is closely aligned to Article 1018(2)(b) of the CAFTA in Corona in Corona versus the Dominican Republic, the tribunal dealt with the same or a similar set of facts and found that it will requiring formal compliance alone would be ineffective. For it to give effect, to the waiver provisions, the claimants would also be required to materially withdraw their cases pending before local or domestic courts. Now, the tribunal in Corona Materials and Dominican Republic considered Article 1018(3), which states that the claimants can bring an application in the domestic courts to stay the proceedings while they wait for the decision of the tribunal. This is to address the claimant's point where they say that if the tribunal decides that there's no jurisdiction, they effectively cannot proceed with their claims. So the CAFTA does provide mechanism for the claimant to also preserve their claims before the domestic courts. So it's not that they do not have any recourse. Now, without wasting the committee's time, and for the sake of providing my fellow presenters the opportunity to fully ventilate the respondent's case, I will give it to the committee to approach me with questions if they have any.
Thank you. Perhaps I could ask you this. Is a waiver nothing more than an abandonment or a relinquishing of certain rights?
It is, Mr. President. That's why the tribunal in Corona versus the Dominican Republic indicated that the claimant still had recourse in relation to Article 1018(3) to have now an injunction to stay the proceedings, so that in the event that they are unsuccessful at the tribunal, they still have recourse. They can still protect their rights and interests.
Yes, but it is your case, isn't it, that the mere waiver itself is insufficient if one interprets the article, that on a proper construction, one must go further and actually take the steps to remove those proceedings.
That is correct, Mr. President.
Aren't we then in a type of onus situation? Because on the one hand, I could say the claimant waives, and then the claimant must take steps to withdraw its processes in the local courts. Or I could say the claimant must waive, and the respondent has the right then, with that waiver, to prevent the local proceedings from proceeding or to cause them to fail because it has a waiver, which brings me back to, is a waiver not just the relinquishing of the rights by word?
Mr. President, the understanding, including from the member states to the CAFTA itself, is that when you formally waive your rights or your claim, you have to follow that by materially withdrawing. And this is the same understanding even under the NAFTA. Therefore, it can't be that it would be the respondent's obligation now to do so.
So let me give you an example, then I'll finish. If in a contract, a party waives a particular right, as often happens, and then at a later stage, that party behaves in a manner which is inconsistent with the waiver which it gave in the contract, is it then open to the other party to say, your waiver is not a waiver, because your conduct indicates it was in bad faith or whatever, and therefore not genuine, and therefore it's not a waiver.
Hence, Mr. President, there's this requirement of material compliance. And that was the essence of the submissions of the Costa Rica and Nicaragua republics, to say that without materially complying, formal compliance would be denied effectiveness and would be misleading.
Despite the fact that there's nothing in the article dealing with waiver that says that. You're saying it's a matter of interpretation.
Yes, Mr. President. And the claimants are solely bringing these annulment proceedings on that, on the basis of saying that this is just a matter of interpretation. And effectively, in Lucetti and MCI power, and I go back again to take cognizance that the committee is not bound by previous decisions, that attainable or debatable interpretation is not annullable. It does not necessarily satisfy that there is a manifest excess of power.
I understand you. Thank you.
Thank you, Mr. President.
Just yes, Ms. Makongwana, just one question from me on your explanation on recourse. And I think it's in your memorandum at paragraph 13, but also in your submissions now, you refer to Article 1018.3. My understanding of that article is in relation to an interim injunctive relief, pending arbitration, So it's not an available course, if the tribunal eventually dismisses, a claim before it. Maybe you can just educate me.
Thank you, Mr. Kuyo on that. So it is an interim relief, that is correct. Hence, even in Corona versus the Dominican Republic, the tribunal said the claimants will still be able to preserve their rights and in their interests during that time that the arbitration is pending. Therefore, in the instance that the tribunal decides that it doesn't have jurisdiction, then the claimants would be able to proceed with their matters at the domestic court level, because they've preserved their rights and interests pending the determination of the arbitration. However, in the event that, and this is a respondent submission, in the event that the tribunal entertains the matter, that's when now that material withdrawal will be effective, because should the tribunal decide the matter against you, now you are now precluded from going back to the domestic courts, because now that would be litigating a matter that's already been decided on.
Yeah, I think maybe we put it simplistically. In this case, they filed a waiver, presumably doing away with the domestic court, proceedings. The tribunal has issued an award upholding the jurisdictional objection. So there are no proceedings, before the tribunal, only for this annulment proceedings before us. Now, my question is, do they still have recourse to Article 1018.3 to say that they're seeking an injunctive relief?
My understanding of that then, Mr. Kuyo, would be that when the claimants are waivering their rights in terms of Article 1018.2b, they would simultaneously apply for an injunction in terms of Article 1018.3. So it will be a simultaneous process, so that as they waive the rights, they still preserve their rights.
Okay.
Ms. Makongwana, just one question following on from what you've just said. If the claimant were to waive by written notice its rights, and as you said now, simultaneously apply for the preservation of its claims in the domestic proceedings. At what point do you say the claimant becomes obliged to formally withdraw those domestic proceedings?
Thank you, Ms. Thank you, Ms. Chisaka, and I'm hoping that I am pronouncing your surname correctly. My understanding of that is that because we are now in an international arena, something needs to happen at the domestic court level. So, and domestic processes will also be guided by domestic laws, and international law does not really interfere with domestic laws in that sense. Hence, the court, the tribunal in Corona versus the Dominican Republic said, you still have a basis upon which you can go back to domestic courts. However, that cannot trump the proceedings now that you've brought before the ICSID, because that has to be determined at that level. And that means there should not be any domestic proceedings that are running parallel to the international proceedings. So, and in the respondent's understanding, Article 1018(3) exists to still protect the claimants so that they still have a way to pursue their claims. However, the claimants have to avail themselves to what's provided for them, but still comply, and effectively so.
I'm not sure if it's just on my side, but I can no longer hear Ms. Makongwana.
Ms. Makongwana, would you just say something else and signify so we can ascertain that you're still on?
I'm still on, Mr. President. Can you hear me?
I can hear you very clearly. Ms. Chisaka, can you hear?
Yes, I can, thank you.
If I could just take the opportunity to inform the respondents that we'll also give you an extra time. So at the moment, you're on 9.5 minutes, but I will give you, I'll give you extra minutes. So you have 14 minutes left. Thank you.
Thank you, Mr. President, and I do apologize to my colleagues.
No, it's the tribunal's fault. We asked too many questions.
Thank you for your indulgence. I will hand over to Mr. Madzibugo.
Good morning, members of the committee. As my colleague has indicated, he'll be dealing with the claimant's third and fourth ground of annulment. The claimant's, the thrust of the claimant's third ground of annulment is that once they had submitted the waiver, they had no other obligation or burden to discontinue the proceedings before the local courts. Now, I think the understanding of the waiver provision by the claimants is incorrect. I think the question that has to be asked first is, what is the purpose of the waiver provision? Now, our understanding is that the waiver provision is a condition precedent for jurisdiction. It is not just merely a defense that the respondents can rely on in domestic courts. It is a requirement that is necessary for the tribunal to have jurisdiction. In the matter of Renko Group Inc. versus the Republic of Peru, they explained the reasoning and the need to comply materially with a waiver provision. It is in a sense to prevent parties like the claimant from returning back to domestic courts in the event that they are unsuccessful in the arbitration proceedings. Now, the submissions of the claimant this morning is to the effect that the burden to discontinue the proceedings firstly lies with the respondent, and secondly, can only be, the proceedings can only be discontinued or withdrawn once the tribunal has accepted that it has jurisdiction. Now, that does not make sense to me, because it seems to suggest that the claimants state that they will waive their rights subject to the tribunal having a jurisdiction. Now that to me appears to not be a genuine waiver, because they're saying we waive, but we'll still go back and have a second bite of the cherry in the event that the tribunal does not have jurisdiction. That is incongruous in our submissions. The second point that we want to make in this regard is that the claimants seek to rely on waste management in support of their proper interpretation, or so they say, of the waiver provision. That they are not required to comply with the material aspects, i.e. not to act in accordance with the stated intention and withdraw the proceedings before the domestic courts. I think from the outset, it must be pointed out that waste management 2 does not assist the claimants in this regard. This is because in waste management 2 did not deal with the interpretation of the previous tribunal, of the waiver provision by the previous tribunal. The issue before the tribunal in that matter was whether a claim could be resubmitted to a new arbitral tribunal with a valid waiver after it had been rejected in the previous tribunal proceedings. Now, I think to reiterate what was said at Waste Management 1 is that in order for a waiver of rights to be genuine, it must not just be an issuing of a statement by the claimants, but also it must be voiced or made manifest in this case by means of a written text and specific conduct on the part of the waiving party, i.e. to withdraw those domestic proceedings. Now, it doesn't make sense then to say that the burden to act in accordance with the waiver lies with the respondent, that it is then our duty to withdraw the proceedings before the domestic courts. I think I must also point out to this tribunal that it appears to us on the reading of the claimant's written submission to this committee that they seem to also agree with this proposition. They rely on Railroad Development Corporation versus the Republic of Guatemala, in which it was held that the tribunal in that matter held that it is the fact that 2 domestic arbitration proceedings exist and overlap with the current arbitration in that matter as determined by the tribunal that triggers a defect in a waiver. So it is our submission that the burden, therefore, cannot possibly lie with the respondents. We cannot be expected, because in our understanding, the waiver provision does not act merely as a defense, that in the event that the claimants are unsuccessful before the tribunal, then we can rely on the waiver provision to say, well, wait, stop, you cannot continue with these proceedings because you have waived your rights. It's a jurisdictional requirement, a condition precedent before which the tribunal does not have jurisdiction. So they cannot say we have to wait until the tribunal has accepted jurisdiction before the waiver, before we withdraw domestic proceedings.
Mr. Mazibuko, if I may.
Yes, Mr. President.
The question of a burden, whether the claimant has the burden to withdraw the local proceedings or whether it should be the respondent who can then put in special pleas or take steps to stop the proceedings. Is that not perhaps a red herring? A waiver is a legal act, and a proper waiver, I think, in most jurisdictions means that the person who has waived no longer has the right to enforce what it has waived. And is that not the end of the matter? And that's a waiver. As I also understand it, the claimant did not furnish a conditional waiver to the arbitration tribunal, and correct me if I'm wrong. They did in argument motivate that the reason they didn't withdraw local proceedings was to keep them alive. But I don't think the waiver itself that was submitted to the tribunal was in itself conditional. So aren't we back to whether the waiver is enough on its own, forgetting about burdens on one or other party? or whether the interpretation of the article means that apart from the waiver itself, which is the abandonment of the right, whether further steps have to be taken, which I believe is your case.
Yes, Mr. President. I think our position is that the waiver in itself, as we understand it, and as it has been interpreted by the tribunal, previous tribunal, is that it is not enough to simply issue a written statement. And the reason we say this is that we can tell even now with the submissions of the claimants that although they say we have waived our rights, we will wait for the tribunal to declare that it has jurisdiction before we can officially discontinue any other proceedings. In a sense, they waive but want to keep their rights alive. That, in our understanding, demonstrates that there has to be specific conduct that shows the respondent, because we have to consent to the jurisdiction of the tribunal, consent to arbitration, I beg your pardon. And in order for us to be satisfied that, in fact, the claimants have indeed waived their rights, they have to do more than just simply issue a statement. They have to evidence their intent by specific conduct.
Okay, thank you. Just on time, just to let you know, you have 5.5 minutes left, the respondents.
Mr. Matuka, sorry to interrupt you again, just to follow on from what the Mr. President has asked. In your understanding, is it relevant if the claimant does not actively pursue the domestic proceedings after filing the waiver? Does it turn anything?
I think it's relevant to the extent that they waive their rights, they do not actively pursue them, under the understanding that if they are unsuccessful, they will return to the domestic courts to re-pursue those proceedings. That is the issue that we have as the respondents, that it is not enough to simply say, well, we've waived and therefore we do nothing. We are required to do absolutely nothing to demonstrate that we have indeed waived our rights. We waive and we wait for the respondent to raise the waiver as a defense in the event that we might proceed with a claim that is covered by the waiver that they've issued. Okay, for the sake of time, for the sake of time, I'll quickly just state what our case is in respect of the fourth ground of annulment. That the claimants had multiple claims before the tribunal, and the tribunal failed to consider those other claims.